All right. Well, welcome everyone. We're now at the halfway point. We're at week 5. We're going to be going over Chapter 6 tonight, which is legal and regulatory risk. When we go through some of this, hopefully it'll make sense. The contractual aspect and the legal risk is something that's probably, again, probably considered boring by some folks, but it really is kind of a lot of things of what we're up against, and especially when we deal with contracts, how do you transfer some of that? And when we talk about legal risks, of kind of how essentially legal or statutes really create a standard of care that make us have to abide by. And then also that's kind of what the insurance industry looks to as well when we look at the liability risk, because what we're talking about is how can we reduce liability for our organizations or recognize the liability through a contract that all of a sudden came upon us because we didn't review those effectively. So with that, although the educational objectives were quite long, that it actually went on to the 2 pages, which is odd, I would probably say that what you need to know on this is we'll probably actually go through this a little quicker than some of the other ones that had shorter educational objectives. But for the first part, we're going to be explaining how civil and criminal law and regulation form a basis for legal and regulatory risk, as well as describe the consequences of legal and regulatory risk to an organization. And then part of what we want to look at is how avoidance and modification of events likelihood and events consequences play a role, and we're going to be looking specifically at torts, those type of things, and negligence, and go into detail. There's a lot of what's interesting is that from an explanation or the objectives, they don't list all those things in there, but that's really what's probably key about this chapter is really understanding how torts and statutes work and that. They spend in the chapter quite a bit of time on other legal systems and civil and common law and do that. Now that's certainly something new that was never in there, but I think what they're trying to do with this is just to give some understanding that there are different systems, and to be able to recognize, if you work for an organization that works in other countries, that there are some implications to that. Be able to distinguish between public international law and private international law. Some good examples. There's not a whole lot, small section on that, but really what that deals with is like NAFTA and GATT on the public side, and then really on the other side, it's more of, okay, does Apple have, the jurisdiction when the courts in, China say, okay, Apple's infringing on Samsung, and basically President Obama said, we're going to ignore it. Basically, that decision, that was fairly recently as well on there. And then finally, some of the legal foundations of some of the commercial liability loss exposures. And they have a whole list of a lot more, but these really are the predominant ones: premises and operations liability, products and completed operations liability, auto liability, work comp, and employee liability. And finally, we'll go through some examples. Last part's more kind of doing a little case study and be able to talk about some of that. So basis for legal and regulatory risk, so the law recognizes every person or entity. So Mitt Romney was right that companies are people to a certain extent, at least in the eyes from a legal and regulatory standpoint, that there are legal interests that an entity has that are protected by civil law, criminal law, and regulations. So essentially, why we can be damaged or harmed individually, so can a corporation, and so they can seek damages for that. And so that's the basis when we talk about the entity or organization. And so violating one of those interests is a basis for legal and regulatory risk. So what are, we're going to talk a little bit more specifically, what are those legal interests that we may have? And so when we talk about the major categories of legal and regulatory risk, first of all, there's torts, which essentially the idea is you can sue someone. That's really what a tort claim is, think about it. Then there's contracts that pose a certain legal risk, and finally statutes and regulations that form some basis, and to a certain extent they're all kind of interconnected. That you can avoid a tort claim by making sure you have good contracts, or if someone breaks the law, you can indemnify yourself through the contracts, which then help reduce the tort claim. So there is some connectedness, so to speak, between all those major categories up there. So first of all, when we really have an understanding of criminal and civil law. So criminal law, I think most people recognize, that's the kind of more you go to jail aspect, and how certain things are pursued. So it's classification of law that applies to acts that society deems so harmful to public welfare that government is responsible for prosecuting and punishing the perpetrators. So really that's where the government will be taking action. Prescribes a standard of conduct by which all citizens must adhere. The written laws specify nature of crimes and punishments. So, I mean, 3 strikes you're out, California, all those things, mandatory minimum sentences, those are all part of the criminal law area. But part of it also, the government must decide to prosecute on society's behalf. Depending, so again, when we're talking from a legal framework, is there enough evidence to move something forward to where they feel it's a criminal act? And there's got to be some type of statute or regulation that they're going for from that. Now, under civil law, again, applies to legal matters not governed by criminal law that protects rights and provides remedies for breaches of duties owed to others. And then also the injured party must file a claim to request reimbursement in the form of monetary damages for harm, typically. Now, the government can also go in civil court. So there are, besides going for criminal aspect, there's also where they've gone after, really most of the, the fines on the banks and all this, the settlements have been more on the civil side. They haven't prosecuted anyone to go to jail, which has been a frustration for many people. They go, well, why aren't you going after the criminal aspect? They're only going after the civil aspect that people were harmed from the monetary and trying to repair those damages on the civil side. And also, I think the thing to keep in mind with criminal law, the idea is it's meant more to be a punishment to a certain extent, of how people do things. So if someone violates, EPA, clean air, dumping hazardous waste, those type of things, they're more likely to go to jail because they've done harm. In many cases, if it injured someone or killed someone, especially when there's that type of malfeasance, then that's probably going to occur. And again, in some cases, an act constitutes both a civil wrong and a crime, and we've seen that in certain cases as well. So a tort. A tort is a wrongful act or an omission other than a crime or a breach of contract that invades a legally protected right. So a legally protected right, not necessarily privacy in this case, but from a discrimination or illegal, or someone does harm to, in some cases it might be they did harm to my, my car. So they damaged my property, which is something that I would own there. So the remedy for a tort is, it's usually going to be some type of monetary damage or replacement of like kind or something along those lines. An organization is liable for any tort it commits through its agents. So when we talk about, through its agents, employees, directors, contractors. So the idea is that, what do you call it, vicarious liability. The idea is that if I hire someone and they're doing my bidding and I've trained them and they end up injuring someone, well, that's my responsibility now because, did I properly train them? What protections? And that goes to the liability of how could I defend myself to say, no, they were properly trained. I did all of these things to help prevent that from happening. When it comes to volunteers, I put examples like Boy Scouts and Little League. Well, they're volunteer organizations. People are volunteering. How can I sue Boy Scouts? Well, people do. They sue Little League because Johnny got hit and was a pitcher and got hit in the head as he was pitching, and so those are fairly common. And so Little League, I'm actually a safety officer for Little League, and one of the things that as part of that, we actually have write up a safety plan. In Little League now, there are no on-deck circles anymore. So because there was too many kids that were getting hit, so the rules are very tight that if the next batter, they need to stay in the dugout and not even pick up a bat until it's their turn out, because what they saw, the injuries, and since they've made all these changes, also the type of bats that are used, all these type of things were the result of because they saw these injuries, and now because of that, they've actually seen a real decrease. because also people would end up suing Little League, saying, hey, you're not protecting the kids. You know that these new bats, these composite bats, make the ball go off quicker. And so again, so even volunteer organizations can be sued. And it could be, I'm trying to think, senior gleaners or some people that deliver food. Okay, if someone gets food poisoning, Meals on Wheels. So there's a lot of different programs. So I want to make sure when people think about it, it's not, and also contractors, if you hired a contractor that's working essentially for you, even if it's independent, you could also be held accountable. Someone could sue you also for the work that they're performing as a result, or them and others, which usually they're going to go for deep pockets. They're going to sue. People are going to go after as many people as they can. So there's 3 categories of wrongful acts that constitute a tort. And the first one is negligence. And that's what we'll talk about. And that's one of the key ones that you're going to want to focus on when you really read the chapter. Because there'll be a lot of questions dealing specifically with the acts of negligence and what they are and how to prevent them. Then we'll talk about intentional torts and as well as strict liability. So if someone, actually, when on the question, there will probably be some type of question, what are the 3 categories that constitute a tort? You want to know all 3 of them, but again, you're going to spin, because then within the negligence, there's a whole bunch of sub-thing categories that you're going to have to be able to talk about that. So negligence is an unintentional tort. The wrongdoer did not intend the action or the consequences, but exposed others to unreasonable danger by failing to exercise the duty of care the law requires under the circumstances. And that's really the key component of there. And the legal responsibility and standard of care established by law are what a reasonably prudent person would do in similar circumstances.
The guy that was involved in the accident, the train accident in Spain.
Spain,
Negligent or just?
So in that case, so the question has to do with what would we call the case in Spain, and I would say that would be an act of I mean, it wasn't intentional, it was unintentional. So now the issue is it's negligence, and so one of there's also the term gross negligence in certain circumstances where did someone know or should have known a little bit about the concern, and based upon it might turn to gross negligence based upon that he was on the phone. Did he violate? It's one thing to kind of be absent-minded, those type of things, but then so those are some of the factors that go into that. Or if gross negligence would be more that I'll use a bounce house. There's some concerns about the bounce house, and you still let people participate. It's one thing, and even though you have people sign a negligence form, the fact that you didn't provide someone to oversee the area to make sure kids weren't doing things they shouldn't have, that might be considered gross negligence in some cases. So the example I usually try to give is, well, what are the duty of care? Well, the duty of care really depends on the industry and what kind of the standard, and it kind of goes somewhat on precedence of what others have experienced, or at least what someone would expect in different situations. So, a grocery store, having worked in the grocery industry, one of the biggest claims grocery stores get are slip and fall claims. Okay, so how do you prevent against a slip and fall claim? Okay. Well, that's warnings. Okay. So there's one way. I mean, because people are going to still slip and fall.
Regular sweeps and documents.
Okay. So basically, what you do is you have to have a sweep sheet program or sweep program. And so the duty of care, what's established, and what the industry standard is, what they expect now, is that the floor in a grocery store should be swept at least every 2 hours. There should be someone sweeping the floor. Okay. Now, is there certain areas that maybe have a higher risk of slip and falls, which would be what? Produce departments, okay, grapes, those type of things. In the produce department, the standard of care is 1 hour. So every hour, there's going to be someone out there with a broom or doing that. Now, you can say, okay, well, they sweep, but someone still slipped and fell. Okay, what's the liability to the grocery store? Well, if you have a sweep sheet program that documents and say, look, the standard of care is we swept every 2 hours, and we have documentation. We can't follow every single person in the grocery store. But if I can show that I took reasonable care, that we followed the industry standard, if this goes to court, they're going to lose, even if the person was severely injured. The issue is when did the grocery store, the owners of the grocery store, know about the hazard? Well, as soon, if someone called, they cleaned it up, they put cones out in other cases. And there's actually a court case, it's Kmart versus Vasquez, I think, that actually talks about this. And actually, I'll have to find it, I'll see if I can send it out. You have a question?
It's the same as constructive notice.
Well, the cone's constructive notice. By putting a cone out, if you know there's a hazard until you can get to it, absolutely, and then you have documentation. And so I can tell you, having worked for Raley's, when people had claims against the grocery store and they went to get an attorney, the attorneys wouldn't even take the case because they know Raley's had an excellent sweep sheet program. They know they're going to lose. They're not going to waste their time, and because Raley's basically defended. They would defend each one of those claims and wouldn't, wouldn't just say, okay, here's money, we'll pay you out, because that's just going to breed more people doing it. So, yeah.
Does California have a shared negligence or shared liability in some of those cases between the plaintiff and the defendant?
Like a comparative liability?
Comparative liability.
To be honest, I'm not sure on. I think it's on specific cases, but basically the idea, and we'll talk more about the comparative liability, is that as part of the investigation process, so this kind of goes, this is a good example of, how you defend yourself against a claim. There's actually a specific form that was filled out, and for just slip and falls. And one of the things that, so anyone could do it, didn't have to be a safety person, the manager on duty could do it. And a couple things, they want people to take a picture. They want to look for, is it raining outside? Okay, so did they already have wet feet as they're coming in? What type of shoes were they wearing? Take a picture of their shoes if you can. So you get an idea, because depending on the type of footwear, okay, well, that goes to the comparative. Well, they're at fault to a certain extent. So now, what ended up happening from a liability standpoint, of course, there's cameras everywhere. And you have a concern of, okay, there's pressure to do other stuff, and do I really want people sweeping all the time? People with dry lab, meaning they fill in after the fact, they weren't doing the sweeps, and then they'd say, okay, let me see the video at such and such so I can see the person sweeping. If there wasn't, guess what? The other side's most likely going to win in this type of cases. So another example that I like to give is that, again, the standard of care, depending on where you're at, might be a little different. So typically for sidewalks for cities, I want to say 3/4 of an inch, just a gap or lip on a sidewalk is kind of considered. Anything more than that, you really need to be corrected. But usually they'll grind those down. But if you're a nursing facility and all the sidewalks are there, is 3/4 of an inch, people are going to trip and fall. Well, in nursing home, people shuffle their feet more. They're not as good eyesight, so you're more likely to have. So the standard of care would actually even be higher. So again, the whole idea of what a prudent person is, standard of care, really depends on the circumstances of what's going on. And so that's why I try to give some of these examples when it comes to negligence and the reasonable person, and how do you apply that? Well, just kind of think of, there's so many different scenarios, whether it be, auto accidents, or, there's enough data to show that, okay, young people have more likely. If you have a fleet, what kind of people you're hiring? A reasonable person would do a motor vehicle record check before they have someone drive a fleet vehicle that's going to be driving around the city. If you didn't do that, pretty much you bought yourself a claim in that case. All right. So some of the intentional torts are actions, unintentional torts are actions or omissions that the wrongdoer intended, although the consequences were not necessarily intended. So example of legal interest by intentional torts include these. Physical safety of one's person is an interest that can be violated by intentional torts as assault or battery. So the idea is an intentional. So unintentional, okay, is the idea that, all right, well, just wasn't thinking, we didn't have a sweep sheet, someone slipped and fell, I wasn't doing reasonable care. When we talk about intentional torts, it's, okay, well, I meant to hit the person, I didn't mean to break their bones, but I wanted to, so that would be something in which that's an intentional tort. So that's why they say assault and battery, the person had some intent to do some harm, but maybe not necessarily the complete consequences that dealt with that. Personal freedom of movement is an interest that can be violated by intentional torts. Okay, so false imprisonment. Are you holding someone? This becomes an issue. So again, if you're in the grocery or retail industry, if you have a shoplifter, there's certain things you need to do. You're making a citizen's arrest. There's certain elements that you have to say so that you don't have a claim of false imprisonment. in those cases. Protection of property is an interest that can be infringed on by intentional torts such as trespass, nuisance, or conversion. So again, someone goes on my property, those type of things, they cross it, they do damage, they destroy my tomato plants or whatever, or dropping hazardous waste on my, they're doing that on purpose. That could be a part of that. Security of reputation is interesting, can be infringed. Libel or slander, okay. Personal privacy, such as invasion of privacy, and then economic freedom as interest can be infringed on by intentional torts such as false advertising, harassing or intimidating competitors or their customers, or any other action that a court determined exceeds the limits of fair competition. So the idea is that someone was kind of, they're intentionally trying to do something, but the consequences, I would say they kind of know the consequences to a certain extent, but just not know how far that those actions were going to take on the effect. And then we have strict liability torts. So liability that does not require negligence or intent. It arises when a company engages in activities that are considered ultra-hazardous or involve product liability cases. And probably the bigger one is product liability. So the idea is that, okay, you put a product out, or vehicle recalls. That's fairly. There's a strict liability. They didn't intend to build a car wrong. So that's why you get recalls. They're trying to fix it so they don't get all of these claims down the road regarding that. You can have poor design of a product, or you have products. If you have products made in China and then they have lead, I mean, we had that issue. I think with Mattel, a lot of the toys were coming back out. So those type of things would be strict liability that on that. Now, ultra hazardous. So some of the activities that used to be that no longer falls under strict liability, but it's a good example of how the laws changed. That for a long time there was no one making aircraft, private planes, for almost like 30 years. I mean, most of the aircraft, your Cessnas were 1970s, Cessna 172s. Part of the reason why that was is because there was a strict liability provision that that really, because if something happened and a plane crashed, they can they can essentially go back to the manufacturer and do that. The laws changed, I think, about maybe 8 years ago. That they basically took that away. So all of a sudden, you see a lot more aircraft being built, private aircraft in there. And that was also gave rise, to a certain extent, was experimental aircraft kits. So people, because they couldn't buy it, they're just making them. But most of the planes that you see flying, the small aircraft, are, they're pretty old. But they just, and most people don't realize you can actually buy a used plane for about $20,000. I did flying at one point too. So. Okay, contracts. So contract is a legally enforceable agreement. So we're kind of switching gears now from kind of the torts area, there. Now we're going to go into some of the contract issues. So contract is a legally enforceable agreement between two or more parties, establishes responsibility of each party involved, and then failure to comply with the contract's terms is considered a breach of that contract. And I think most people, okay, there's contracts. We've all signed probably many, and we've never really read them. All the fine print in most cases, and what we're actually signing. A lot of times, most people, that when you go online to a website and use agreement, and you're clicking the button, you just signed a contract.
Agreements.
Yeah, the agreement, and it kind of goes to, and we'll talk about some of the things in there. Again, how companies are limiting their liability in those contracts of what people aren't reading, and so they understand. If you use a storage facility for all your data, okay, well, what's the contract say if something happens? I think, especially if it's if it's one thing, it's all my pictures. Okay, well, that's or my music or whatever that and the cloud. But if they're business documents and they're lost, what are they going to do to back up? What's their downtime? Those type of things need to be specified. Individuals and businesses can become liable basis on the contract's terms, or based on the terms, inferred from the contract. Okay, so there'll be specific terms inferred from there, but then also there's implied warranties. Implied warranty is more of the expectation of, if I bring my car in to be serviced or something, or I bring, dry cleaning in, the implied contract's not going to be damaged when it comes back out. So there's certain expectations of the performance of duties that there's somewhat of an expectation there. So requirements for enforceability. Okay, 4 requirements can be questioned. That there's going to be something like this, a question saying, okay, what are some of the elements that you need to consider? There'll probably be a scenario. So you're going to have 2 types of questions, but I pretty much guarantee that there's going to be a question that's going to ask, what are the 4 requirements, or which one of these is not a requirement, or something along those lines. So first of all, their agreement, offer and acceptance. One party makes an offer that the party accepts and must agree on the terms of the agreement. So first of all, so that's the first part. There's an agreement. There's consideration. Each party gives something of value, money for service or promise to perform. Okay, so contract to build my house. Okay, well, there's going to be a contract. The price, I'm going to pay you this much, and you're going to build a house that looks like this, and we're going to have plans, and we're going to have agreed upon, and what exactly, there might be delivery dates that are set in there. So that's part of the consideration. The capacitive contract, which is basically, hey, if you're under 18, you can't enter into a contract, legally. So adult, you have to be an adult, sane, sober, all those things that someone, in order for someone to be able to sign that. And then also must serve a legal purpose. So it must have a legal purpose and not oppose to public policy. So the example I kind of put, a contract for prostitution may be legal in some counties of Nevada. All right, so you can say, okay, brothel or whatever. I don't, to be honest, I have no idea if they have contracts, but there's probably, but the idea is if you, sign a contract as a hitman, okay, well, yeah, it's a contract, but it's not, even though they even call it a contract on someone, it's not legally binding, serves no legal purpose because it violates the law. So it's not like you can sue someone for, hey, the guy didn't pay me for, doing this type of thing.
Are there verbal contracts?
So yeah, so there can be verbal, and so, but that's the challenge. Okay, so, you can have a written, obviously a written contract is really what you want to have. An example, you do have verbal. So there's, I don't know if I put it in here. I was thinking about it at least at one point. There's actually, it was in the papers recently that Pawn Stars, that it's based on an A&E show, that supposedly the agents had a verbal contract with the stars of the show to help do something, and he's not getting paid his royalties. Well, it's a verbal contract. There's it's a he said, she said. There's nothing there. I mean, it depends on the scale. What I can tell you, when I worked for Bickmore, one of the companies that actually we were meeting with was actually Les Schwab. And what was surprising is, Les Schwab's all over the place. They actually had handshake agreements with a lot of their suppliers. They really grew from the ground up, and that's one of the challenges for small companies that are very much in the personal nature, and that's what, they're very, family oriented, which is great, but that doesn't work when you get so big, and so they run into issues, and that's what, in fact, if something was to happen to, and this was the time they came, was when the whole tire thing with the Ford Explorers, I think, was, and the tires and all that. And so that became an issue. And so they started thinking, well, maybe we should start looking at having written contracts.
Probably good in the 1920s.
Yeah. But, yeah, you can. And they can be, if both people and they go to court and say, yeah, we agreed, and well, if there's disagreement on terms, but again, that's where a verbal agreement falls apart, because while you may agree in concept, it's really hard to say, okay, we agreed specifically on each one of these terms. And maybe nothing was ever signed, or maybe there's some emails that go back and forth, but that's why signature is really important to have those.
Okay. The agreement piece, I'm just thinking of the parking lot that I just parked in a parking structure, where you just get a little ticket, you take it.
Mm-hmm.
On the back, it actually talks about this is a contract.
Yep. Absolutely.
I don't actually think of that as something that I accepted. Like it's simply that.
Well, you accepted because you kept your car in there. You didn't leave.
Yeah.
And so that is part. And so yeah, that's a good point. Is that there can be agreements where you say, well, I didn't agree to this. Well, you kept your car there. You actually read it. Did you read the sign? Well, that's not my fault you didn't read the sign. Now, and that goes, when we talk about postings and notice, there's usually that big sign when you enter saying, there's some sign somewhere as you go into a parking garage saying this is not a condition of bailment and anything, or there's a contract language of some type. So they're going to do one of those type of things. And now the issue is, technically, if you say, okay, well, if I'm 16 and driving a car, well, that contract may be out the window because I can't agree to that, and something happened, and I can, so that might be something to where it may not protect them. The other thing you have to keep in mind is a lot of organizations, companies, will put those things on there to deter people from even thinking of filing a claim. And an example, again, I'll give is in the grocery store, shopping carts. Shopping carts, if they have the cart corrals, there'll be a sign saying we're not responsible for damaging any vehicles while in our parking lot. Well, people say, well, say it's an act of God. What that basically does, they go, oh, okay, well, I can't, people won't even file a claim. The reality is if they file a claim, they will most likely get, they could probably win, because the issue is, well, there's an expectation at some point that you need to get all these carts. And because of your negligent in that you weren't collecting these things, you had to know that wind or other things will cause this. Now, for those that shop at Raley's or Bel Air, for a long time, at least Bel Air, they never had cart corrals. And one was because it was a customer service issue. The other issue was, for this very reason, is because there's always someone out there collecting carts constantly. That was part of the job, to reduce the amount of claims, so that way there wasn't this issue. Otherwise, all these carts get stuck out there and then they hit cars. So there wasn't even a spot to put them in. The expectation was every person's groceries. So it was a customer service issue as well as the other one. So we do have a couple. Looks like a question here says football player Aaron Rodgers' Twitter scandal was their consideration for a contract by both parties. Aaron Rodgers' Twitter scandal. I'm not too familiar. I know, because I know the whole. I think I know that Twitter. To be honest, I don't think I have the details on that one, so I'll have to, maybe I'll get back to you on that one. So unfortunately, I can't really answer that question because I'm not sure the details. Typically, I mean, I'm assuming there's people, 140 character contract in Twitter, I guess. I don't know if they could be necessarily legally binding in that case. Even if they did kind of say, hey, don't share this with me, there's no agreement. I mean, even if they said, it wouldn't be, what's the consideration, those type of things. And again, maybe it's legal, whether the activities were legal or not also throws in, I'm assuming that maybe some pics or something like that. All right, so I gave an example of my weight loss contract. Okay, so I actually did this about 3 weeks ago. So I have a contract with my wife and kids, actually. So they can't contract, so it's really with my wife. They're under 18. So it's with my wife. That would lose 35 pounds by November 16th, which is my birthday. With term specific of weekly weight loss goals and performance requirements like no sodas or beer. There's also at least 30 minutes of exercise each day, all this other stuff. So there's actually, there's a lot of, there's some very specific things in there. And because I'm very anal about contracts. I mean, contracts are contracts and those. And so I've always, most people struggle. And there's actually, there was a article again, a couple, probably about a month ago, saying what, if you put like betting or those type of things, put a value on weight loss, actually people, because now there's a more incentive to do that. So again, so part of this, failure to meet weekly goals or breach of term of the agreement requires me to give $100 to my daughters to go shopping. So the other part about me is I'm pretty stingy. So I hate, I don't mind shopping and those type of things, but I'm just, not willy-nilly. I don't, try to do some of that. So really the contract is, we look at, we have an agreement, we have made an offer, there's an acceptance of the offer consideration. Obviously there's the monetary, but for me it's good health, as well as, this has been recorded for a long time, nagging about what I eat and those type of things. Actually what it is I snore, so if I get less, snoring, so I won't be hit all night is the consideration, and then I'll actually get some sleep as well. Obviously, for me, getting help. The capacity to contract, we both have the capacity, and there's no, has a legal purpose, not opposed to public policy. So, actually, I've been, actually a little over 2 weeks, so 12 pounds already. So, I'm right, I'm actually ahead. But it actually does, one of those things like, oh, no, I can't have that. No, that's a breach of the contract. No, oh, no, got to do that. And so it is actually, it's one of those things because that's something I, really, it's a constant reminder of, no, these are the performance expectations that you set up, whether it be a vendor, that they're supposed to perform in a certain way. So anyway, so for those that have that need, it's one way. It's one way to do it. So if you want to copy my contract, if you need to do it, I'll be happy to share that with you. So the types of contracts. so we talked a little bit about an implied contract is contract whose terms and intentions are indicated by action of the parties to contract and the surrounding circumstances. So, you know, the idea is, okay, the dry cleaning, I'm going to give you, I mean, technically everything exchange of dollars is essentially somewhat of an implied contract. You know, there's not necessarily anything written, but I'm saying, hey, for this you're going to clean, you know, do dry cleaning, and I'll give you this many dollars for that service to do that. Express contract is whose terms and intentions are explicitly stated, and so that's what most contracts are. They're express. And so when we talk about these are terms, they kind of take types. I would almost kind of disagree. These are more because an express contract is most likely a valid contract, or a valid contract might be, you know, there'll be many of these things in place. So a valid contract, a contract that meets requirements to be enforceable. So those 4 criteria that we just mentioned on the last page. And then you have a void contract, despite intentions, an agreement that never reaches contract status and therefore not legally enforceable. And that's what I did mention. The Pawn Star shows that it was a verbal. There's nothing in writing. There's nothing. So it's not really a true contract. There's no signatures in place. You know, so you might have had everything there, but if there's no one, the other party didn't sign, it's going to most likely, if you try to sue, it's gone. It's not going to go anywhere. A voidable contract, contract that one of the parties rejects or void based on circumstances surrounding its execution. So even though it's signed, and later you realize, well, that person's a minor, well, it's void. And so, there might be some other things that, because again, someone withheld information, or it's, you know, deemed some other things, that a contract might be voided based upon that, or, you know, a conflict of interest or some other things. Unenforceable contract. It's a valid contract that, because of a technical defect, cannot be enforced. So, you know, it would be, example, like a verbal real estate contract. You know, real estate, and they mentioned, you know, really it's required, you know, because you have title, you have all these other issues. There has to be a written contract. It just can't be a verbal, and because of all the provisions that go with that. All right, so now we're going to move to statutes and regulations. So this is the third area. So yeah.
Real quickly, contract has to have each one of the elements. It can't have two out of 3 or 1 out of 3.
So on the 4, you're talking about the 4? No, it has to have all 4. So all 4, and so yeah, that's key. So, so the 4 requirements: agreement, consideration, capacity, contract, and legal purpose. This is definitely one thing you want to memorize, and that's why I kind of, you know, put that in red. The 4 requirements will be something that's definitely on there. All right, statutes and regulations. So statutes are created by federal, state, or local governments and often modify the duties owed to others. So even though there might be, you know, there's some standard duties owed based on reasonable care, but this is now specified, you know, a statute says, no, you will perform in these type of things. You know, a good example, you know, barber shops or, you know, cosmetology, you know, you have to have a cosmetology license, so that's a requirement. There's a, you know, you've actually been trained. There'll be inspections, or actually a better one is food service. There's certain duties owed that you need to make sure that you keep proper temperatures and all that. That's done by regulation, and that's now a duty owed. And also that's what a reasonable person would expect type thing as well, but that's where that comes from. So violation of statutes are the basis for most criminal cases. Violation of statute may also be used as evidence the organization breached the duty of care owed to others. So depending, you know, again, it says for most criminal cases, just because you violate a statute, it might still be more of a civil type, you know. Okay, so we have speeding laws. Okay, people violate speeding, you know, go past the speed limit all the time, or they're talking, texting while driving, or they're doing those type of things. In most cases, you know, again, it could have, you know, or DUI, that would be more of a criminal. Something rises to the occasion because now it's one thing to pull someone over where they're drinking because they violate a statute. Another thing when they actually get in an accident and they kill someone, now it's even risen. Now that's where it's going to rise to level where it's probably going to be criminal, even more so, where it might have been a misdemeanor. But usually it spells out within the statutes of what level, what type of fine and penalty. So there's some type of structure there for that. And then a lot of times, so what you typically, excuse me, what you typically find on the violations is, if I'll use Cal OSHA for example. So if there's a deemed that someone was injured, and then Cal OSHA does an investigation, they say, well, you violated these specific regulations. the person at some point possibly could then use that to sue to show negligence on the part, especially in a case where it was a what would they call willful, serious and willful situation. Then most likely that could be used as evidence, and those are also public documents that can be used, and so they can be brought into the court to say, from a civil action, I deserve compensation for that. Excuse me. Regulations are developed as directed, required by statutes, and have the force of law. So, the EPA, OSHA, Education Code, there's some type of statute, that was passed that says that gives the powers to the regulatory body to create regulations if they follow a certain process. So most of the Cal OSHA regulations are, they go through a public hearing process, there's some vetting, they create standards, and then they become a regulation, which then can be enforced on employers. In some cases, there might be statutes, which I'll use one for hospitals. So patient handling. In California, we have a safe patient handling law that was actually passed by the legislature last year, became effective last January 1st, and actually specifies and actually does have the force of law. Now, part of it said that Cal OSHA had to develop specific regulations as well, but even without, because of the way it was written, Cal OSHA, it's still enforceable without the regulations being in place. And so they can still enforce it. And that was the challenge of, they put a law in place, but you don't know what your standard you're being held to because the regulations haven't been written to say what it should look like. And then same thing with Education Code. I mean, there's tons of regulations that, there's for, and some are more civil rights type of things. Maybe at the federal level. Williams Act, I think, is a federal. Maybe it's, which basically means that the Williams Act is a requirement that public schools need equal and fair education, fair education. And so the idea is, does every kid have a textbook? So those are requirements. If you have a class that requires internet or access to the internet, well, then if that's part of the requirements, then you need to provide that, and otherwise you violate the Williams Act, and then the district can then be sued for violations of that they didn't provide, or the students can be allowed to transfer to other districts at the cost of the district in some cases. So major consequences of legal and regulatory risk, well, there can be monetary damages, and those are usually in the form of fines. You have defense costs, and you also have indirect costs. And then, excuse me, I'm getting water here, so one second. I'm actually going to pause this for one moment. Within the categories of consequences, so fines would be monetary damages. You have defense costs, which might be also court, indirect costs of overtime, things like that, and then specific performance or injunction. And so one of these I'll just mention, because it's also for universities in the public domain, is we had in 2008, the laboratory incident at UCLA, which was originally a Cal OSHA fine, which is about $32,000, in which we had a researcher that was injured, with a fire. It was a laboratory incident, which eventually led to her death afterwards. So Cal OSHA did their investigation. There was monetary damages as part of that. Well, that was actually turned over to the Los Angeles District Attorney under California law, under Labor Code 6425. As an employer, we can be held accountable for that. So then at that part, we also incurred defense costs to do that, and then the indirect costs of people's time being spent on that specific part, and then eventually there was a settlement, which directed, as part of that settlement, we had specific performance requirements that we have to meet as part of the settlement requirement. So when that kind of gives a framework for those that work in the university system of kind of here's all the different things. And so in this case, we had all four major consequences really part of that. And in most cases, if it's just a fine, if it's Cal OSHA, those type of, or EPA, you might only get the monetary damages part. But then if you decide to defend and all that, then the things start growing and it can certainly escalate.
So you guys lost the case. What about the?
Well, we didn't. Well, we settled. So I mean, there was. I mean, so part of it was there was a decision, and that point is part of the. When we talk about this, is what point do you decide you want to go?
Cut your losses.
To, you know, of what makes the most sense and what's the appropriate thing to do.
So what would the plaintiff's attorney's fees come in? Would they be direct costs? That's part of the settlement.
No, that would be the plaintiff's attorney. If, you know, depending if we had to pay, you know, plaintiff, yeah. Well, in this case, it wouldn't necessarily because, again, legal consequences, regulatory, it's going to be the government. So typically the government doesn't end up, they don't usually do the court costs. Now, if it's a civil case, then yes, there's usually that. Now, the only issue that I'll just kind of raise from what's unique is a lot of times there's focus on Americans with Disabilities Act or ADA lawsuits. What most people don't realize is, for the most part, ADA, the way the law is written, it's enforced by the public through civil lawsuits. It's not enforced through the criminal. It's not enforced really by the government. The Department of Justice can go in certain cases and do some things. But for the most part, and that's why you hear in the news of people that are getting these letters and then they have a civil lawsuit and pay $5,000 or whatever because it's enforced. You know, someone goes, they said, look, you violated my rights of not being able to have access to these type of things. And within the ADA, there's very specific specifications of, you know, the height of the mirror is 40 inches and everything. I mean, there's really specific requirements. And if they're off technically by 1 inch, you can go in and that's what people do. They will go in and say they'll sue because, you know, the flush handle was on the wrong side. There's all, you know, 5 pounds, less than 5 pounds of force to open the door. There's very specific requirements within ADA regulations.
I guess you're living going around suing different entities because of having wheelchair access when you approach the curb. Those ramps was a real issue all through like Walnut Creek, Contractual County. He would basically file those claims and would be awarded damages because he didn't have wheelchair access to curbs.
And also, you know, there's Herb's giving me examples of some, you know, of where someone might not get access, and you kind of have someone that just kind of sues, goes to city, and that's actually happened. So a couple things that have happened, just, you know, as background, because this is a big risk for every organization, whether it be public or private. So some laws have changed that don't allow that the person suing actually has to be the person, you know, that was rights were infringed, because before it's just people saying, hey, let me know, and they're like, I'm doing it. The other part was to actually they created what they call within the Division of the State Architect, the CAS program, which is they have a Certified Access Specialist Program, I think what the CAS stands for. And essentially what they did is they created criteria to certify, because there's all these people saying, look, I can make you ADA compliant. So they create a certification program that can help entities, one, look at plans to make sure that they're appropriate from so all plans now in California has to be stamped by a CASP-approved person for the public access, so that we get that. But you might also see on some buildings, you can say, there'll be a sign saying ADA improvements in progress. And so the idea is that people, you know, employers or can have malls or whatever, they can actually hire someone that they know is certified, that knows the laws, to actually take a review, look at what they need to have, and then come up with a list. And then part of that, they have some immunity that they can't be sued, as long as they have someone certified, they have a past person that did the certification, and then there's a reasonable time frame to get those corrections done. But that actually, by doing that, so that's, you know, we talked about certain things you can do. That's one thing an organization can do to make that happen. But a lot of times cities get sued, and then what they have to do is establish a program over the next 10 years. X amount of dollars have to be dedicated towards sidewalk access and those type of things.
And Napa has that program. If you ever go to Napa, the streets and the pavements are horrendous. And I analyzed up there for a few years, and that was probably 60% of our claims.
Yep.
And
then you go. I mean, the whole city stuff. We can at some point we'll talk about what's called design immunity. But so there's certain immunities that can be done, and that's more for government entities, and I'll mention that a little bit later. So part of the things when we talk about monetary damages, obviously there's compensatory damages, which indemnify those who incurred losses because of a breach of legal responsibility, include special damages and general damages. So basically, that's what you actually incurred. If my vehicle, you know, was not, you know, it's worth $5,000, well, that's what I'll be compensated. So you think of compensation, compensatory. Special damages are for specific or known loss amounts, such as the cost of medical care. General damages are for non-specific uncertain loss amounts, such as pain and suffering or loss of companionship. So, if I say, okay, this pain, all that, so that's where you're going to get some of the general damage. Punitive damages are to punish the wrongdoer and discourage future acts. And so the cost of verdict settlements or fines represent liability, loss, penalty, and fault. And that's usually what gets fought in courts, is that you might have this, but then they have punitive that's really, really high, and then that's where all the fighting happens. Now, for the most part, government entities are exempt from punitive damage awards. That someone can't, those cannot be awarded, at least for UC work. I know we're exempt from the punitive damage aspect. The other cost, defense cost, which that includes investigation, and defense costs can be the most expensive liability and may require intensive investigation, legal work, use of expert witnesses. Defendant usually pays all costs imposed by the court, including jury fees, filing fees, premiums on the court bonds. So there's lots of costs there. Indirect costs, well, there's obviously, a loss of reputation, a loss of revenue, market share. So because of this situation, the indirect, obviously there can be people working on it, that you have more people overtime, or you have to fix those things. But then just the other part is you may lose business because of that, which now becomes an indirect cost because you're not making as much money. Then specific performance or injunction, the wrongdoer to complete performance is specified in the contract. And so, a court can also order a party to refrain from doing a particular activity, which is called an injunction. And both cause liability losses because of an associated defense cost. So those are the type of things when we look at that. So modifying legal and regulatory risk. And so what we're going to be going through on each one of these is looking at, okay, well, how can we reduce tort? How can we reduce these, these different areas using some of these techniques? So, so on this part, modifying legal and regulatory risk aspects. So risk avoidance, okay, not doing the activity. We can say, something, the risk from a regulatory standpoint of, treating hazardous waste, or something that poses a legal obligation. We say, it's just not worth it. We're not going to do that type of activity, and we're just going to avoid it. We can modify the likelihood of event, which is really loss prevention, or modify the consequence, which is the cost aspect, which is loss reduction. In certain circumstances, risk sharing, insurance, or retaining the risk may be appropriate. And so, in many cases, I would probably say that's really, probably happens more often than not. There might be some, risk sharing or retaining of the risk. Understanding that, hey, the violations are going to occur from a legal regulatory standpoint. So modifying likelihood of tort liability. So, so when we look at contractual removal or limitation, so what this whole section now we're going to look at tort and what are the ways we can modify the likelihood of that. So one way we can modify or limit it is through waivers. So most people, when they sign a waiver to do an activity, we now reduce our, that liability. We say, okay, well, I'm going to waive my ability to basically sue you if I get hurt. So that's part. So that's an actual signature. A hold harmless agreement. It's a contractual provision which one party agrees to assume the liability of the second. So usually, if I'm doing work, or people do work for us, we ask that there's a hold harmless. So essentially, if something happens that and someone sues us, they're going to pay all the costs. That's their responsibility. So it's kind of the risk is transferred through a hold harmless aspect. Exculpatory agreements, it's contract provisions that enable a party to avoid liability for negligence or wrongful act. So usually there's agreements. There's really all these elements. Typically, there's they're going to waive their right, they're going to hold them harmless, and they're also going to release of liability. So bounce houses, or there's always mostly have there's a release of liability form. Community service districts. This is actually pretty common. There's usually a release. There's a contract. So if you let your kids play a sport, that they're going to have to sign saying, hey, they're going to waive their right to not sue and those type of things. And so what has actually happened within the courts, this kind of goes to the gross negligence and how can you improve negligence aspect. What the court said is people, and this goes to the agreement of people knowing what they're signing, is that there's certain activities which you may know might be more dangerous. So if I'm going to do wrestling, Okay, well, there's more harm. So to have, what you'll see now is most community service districts, they won't just have a blanket agreement where they used to have it. They'll say, oh, you're doing football. Well, in football, there's the risk of hitting, falling, there's the risk of these types of injuries. Because now there's acknowledgement, specific acknowledgement by the parents, in this case, that they know what the harm potential could be. Because before it was generic, they, a form, and they're using this one form for other activities that might be, let's say, mixed martial arts class, okay, or then basket weaving's one less, or those. There's different hazards, and so you need to recognize those. And so that's what the courts found, is that these blanket documents really serve no purpose. And then also the courts have found recently is that you cannot waive gross negligence. You can waive, you can waive negligence, but you can say act of gross negligence on my part. The courts have said no one can ever waive gross negligence. And so you'll see that's really been taken out of what used to be in forms as well. So again, usually in the form of release liability agreement for activities specified in the contract. And what I can pretty much, my own belief whenever I see these things is really not, it's more of a deterrent, because if they're not maintaining the facility the way they should and those type of things, they can still be sued. And so, but that's one of the ways that they're trying to get people to recognize and try to say, hey, you can't sue us because you signed this form. Well, the reality is it doesn't matter what's on there. Anyone can sue. Then let the courts decide of whether there's actually any real claim there. The last one is unilateral notices. Notices that are posted so they are physically apparent, expressed in language the other party understands, and reasonable in extent. So parking lots. Enter a park, signs in parks regarding hiking, hey, there's possibility of snakes, there's, falling rock, those type of things. And the other example I kind of give, when you look at, example, how many warning labels are on a ladder? Okay, there's tons of warning labels. Or if you look on a plastic bag, this is not a toy. Do not put, okay, well, why do they do that? Unilateral notice. It's to, what's some other things?
Used to be the ones right in the bags too. Because now it's what you call suffocation.
Yeah, suffocation. They'll put that. The other one is if you look at hair dryers. Do not use in the shower. Do not. I mean.
Do not use while sleeping. Do not use underwater. And there's one other I can't.
So pool toys that says this is not a flotation device.
Yes, so all those. So the whole idea is we've kind of gone crazy with signs, but the reason why is because the idea of providing unilateral notice. Now, why did they end up putting the notice? Is because someone probably sued and they won, and so now everyone goes, and now that's the reasonable care aspect of that. So someone said warning signs on lawnmowers. Yeah. ATVs do not, over a certain weight limit. I mean, all those things, because if someone does use it and then they get hurt, it's like, well, no, you were over the requirements of what that was supposed to be. So, yeah. So that kind of gives you an idea. So by doing these type of things, that's how you can limit tort liability. Again, people can still sue, but you're more likely to win in that case. So hazard control as a removal or limitation of tort liability. So first part was we were talking more about the contractual portion. Now the other way we can do it is through hazard control. So a hazardous condition that increases the frequency or severity of a loss. So hazard control is usually specific to risk exposure covered under an insurance policy. So so premises and operations. Well, we know premises and operations, parking lots, walking surfaces, merchandise display. So the exposure we have is, when we have a premise, what can happen? Well, slip and falls, trip and falls, carts hitting, whatever the case may be, that's part of it. So the idea is how can we eliminate some of those hazards? Well, making sure that we have good striping and things like that. Products and completed operations. So this measures vary by the product manufactured and type of operations, but usually the control when you're doing production, it's quality control. You're going to test so many widgets out of this to say, okay, we've done that. The other way you can, obviously proper design. Okay, we went through Q&A. This is good. Electrical components comply. Gets UL certified. We've done all those things. And then also the other part is clear instructions and technical manuals. The manuals that men never read. That and basically, and part of this, the reality is that when they put all those instructions there, and if you put it together wrong and you end up damaging it, and then you end up with those extra screws or whatever, it's like, well, you can't reach. No, they provide. We gave you the instructions. You did not follow them, and that limits their liability and how maybe it probably might be used as well. Primary, now modifying likelihood of contractual liability. Primary measure to reduce contractual liability is to have all contracts reviewed by counsel before signing. That's before signing is the key. Again, written contracts rather than oral contracts. That's the other way. And also the idea is that contract really must accurately reflect the intent of both parties. Modifying likelihood of statutory liability. Risk managers must understand statutory and regulatory requirements applicable to their organization. Well, so basically it's knowing, okay, if we produce chemicals, well, what's the requirements for disposal? What's the storage requirements? All that, and how you do that. And you can have internal experts. You have an EH&S team. Trade associations are really good at providing advice on, here's the exposures for if you're doing these types of operations. A good one. Actually, so pest control. Pest control, actually they have their own captive. So they provide advice, so they have insurance, they'll get advice and say, okay, here's the regulations on locking, here's all these type of things if they're in that. And then as well as external experts can help identify. And that's really where the insurance companies can kind of come in and say, oh, you have this exposure, you have these things, and then hopefully they'll say, here's how you might be able to control some of those from a statutory. So you make sure you're following the laws and regulations. Because just saying, oh, I didn't know there was a law, it doesn't work. As part of, so that once you identify those, develop a compliance plan, assign responsibilities. The board of directors as well should have ensure the organization follows the laws and at different levels. So you have Sarbanes-Oxley, OSHA, EPA, but they need to give direction. But that's the idea there. Then you also have corporate code of conduct. One of the things they mentioned in the book is a technique to modify likelihood of statutory liability. The idea is if you have this code of conduct saying we will abide by the laws and these type of things or the standard by which you're going, what it does, especially for multinational companies, it says it doesn't matter if we have a factory in Bangladesh or these, we are going to practice these standards. This is our corporate standard of how we're going to treat people. We're going to follow these laws. Just because they're in different countries, they're not going to lower their standards is what they're doing.
Even if it went against, let's say with Nike, how Nike's producing, allegedly using child labor, that goes against, statutes here.
It goes exactly. So that's the example. Is that, and that's kind of the example they give in the book. So the idea is that while it might be legal to use someone that's 14 to make shoes in another country, from a corporate code of conduct, that's the idea. Is just because there's no laws in that country, the idea is that we're still going to follow those. Because, and it's also from a reputational risk standpoint. I mean, there's other aspects that go kind of do, and it also kind of sets the idea of it's easy to follow one standard of regulatory policies if you say this is the standard by which we are going to operate. And I would even say, for the university system, 10 campuses, they each have kind of their own policies. So the move we have personal protective policy and lab safety. The idea is we now have a system-wide standard of expectations because a lot of times regulations can be interpreted a little differently depending on who you ask. And so that's kind of part of the plan there. So modifying consequences of tort liability. So now we're switching back on this. Now we're looking at the consequences. So development of defenses and participation in settlement negotiations are two methods to modify consequences of tort liability. And so some of the defenses that we'll talk about. So when we talk about development of defenses, there's legal privilege. And the idea is concept that an organization has a right to invade others' interests to promote or protect one's own greater interest. So example might be, in this case, the common law places more importance on protecting persons than on protecting property. So someone can assert legal privilege that, this is in the best interest. This is better than the other piece now.
Like eminent domain? Eminent domain?
Eminent domain, I don't know. I mean, because that's a law that, I mean, there's a law that allows for eminent domain, so I don't know if that would necessarily apply, but to say that you know, I'm trying to think of a good example, but you know, because they don't really provide that many good, you know, examples specifically. They kind of just give the, you know, the idea of what the legal privilege is. You know, the other part of the, you know, we talk about privilege is, you know, rule of law allowing a person to refuse to disclose confidential communications. Obviously, most people know what that is, but the legal privilege, you know, that I have a right to do something. Well, this is, I would say, that to a certain extent, this is probably what Snowden may claim, is that, you know, even though there's laws that say I can't do this or other things, that there's justification. Now, that's laws and regulations. We're talking about tort, but there might be some circumstances to where, you know, I'm going to, yeah, I'm going to, actually, here's, might be an example. Someone trespasses on property, but to save someone's life. Okay, well, yes, they trespassed. There's a tort that someone could say, well, hey, you damaged, you broke the window, you did all these other things, but for legal privilege, like, well, no, but there's a higher value in saving life than there was over property. That's probably the best example of it. Immunity, defense that in certain instances shields organizations or persons from liability. So typically government entities have certain immunity. And so one I mentioned earlier was design immunity. And the idea behind design immunity is that that it goes for construction, but a lot of times design immunity is used especially for dangerous intersections. And the idea is that intersections are, you know, has an accident, and maybe you have multiple accidents. Someone can say, well, this is a dangerous intersection. Look how many accidents have occurred here. Well, under design immunity, as long as it's signed off by a traffic engineer within the county, or whoever, it's a traffic engineer in general, who, you know, is the knowledge, who's the expert. Basically, the courts give design immunity, saying, no, this was designed by someone, there's certain, it has to be reviewed every so often. There's what they call SWITA reports, but they have to follow certain things to retain that immunity. And so that might be one way to do that. And so there's other immunities that might also be granted in certain circumstances.
I know with police officers, you know, running code 3s,
mm-hmm.
sirens blaring, whatever, if they have an accident, they're immune because in the performance of their job, you know, they're protected. So, and yeah, so the comment was regarding police officers, and you know, if they're in a high-speed pursuit. Now, those immunities have been reduced for police in certain circumstances because they actually have to follow. There's requirements that they have to do certain steps to get approval before they go through. They can't just flash lights and go through a code 3. They actually say, okay, this is the circumstance, because also at some point they need to cut off because the issue of them injuring someone else from a safety standpoint, and actually, and I think most of the regulations, they actually end up having to do it. The sergeant has to then approve, you know, either on there that they can go code 3 and basically go through there. Because if they do it on their own and then they crash into someone or kill someone, without, you know, they would have immunity in that case as long as it followed the procedure. And that's why procedures are so important. If a procedure is not followed, that immunity is gone in those cases. Okay, so the other types of development defenses, comparative negligence, and this is what we talked about earlier, is common law principle that requires both parties to a loss to share the financial burden of the bodily injury or property damage according to the respective degrees of fault. So just because I had something on the floor, slip and fall, and we say, okay, they had $100,000 worth of medical bills, but the comparative damage negligence is, look, they're wearing flip-flops, they did this, they weren't, you know, other types of things, and the judge determines, like, well, they're 50%, you know, at fault, then they're only going to recover the $50,000, not the full $100,000. And so now there are some, and I think California is one of those states, or at least it was, and certainly for workers' comp, is if it's 50% plus 1, you bought the whole thing. So you know, so there's certain cases of, you know, where the comparative negligence goes into play. Last clear chance doctrine is a defense that holds the party who has the last clear chance to avoid harm and fails to do so solely responsible for the harm. So the example they give in the book is, you know, being hit by a car when running a red light. Okay, you know, if you're trying to cross and you're crossing when the light's not, it's not your turn. Well, you should have known, and you know, to a certain extent. I would also say signage for wet floor. That okay, that's you had the sign up, they knew about it, you know, or this is also where a lip on a pavement, there's, you know, spray painted. You know, did they have a chance, or they saw a big hole, even though there might be a hazard, they recognize it,
but a reasonable person could have avoided it, is the idea. Did they have enough time? Did they have enough warning? And so that's where the last clear chance doctrine, and so we can say that's what they're going to try to assert. Or that's why we would say, hey, we had our cones up, we did everything, and you still slipped and fell. How could, you had a chance to avoid it and you didn't, and you walked right into the hazard knowing it with a sign there. Well, there's something you're liable for that. Assumption of risk is a concept that a plaintiff had sufficient understanding of risk and a reasonable prudent person voluntarily accepted the risk. So the doctrine of assumption of risk is, okay, I go skiing. Okay, there's, if I break my leg, well, I knew that was a hazard. Matter of fact, when you buy your ticket, they say you're assuming, and they'll actually say this, you're assuming the risk of, and they'll actually have that language. There'll be signs posted, so that's where the assumption of risk comes in with those type of activities. Settlement negotiations. So this is first with development defenses. Now we're saying, okay, the other way we can do it on tort claims is to reduce the consequences, the cost, is to go into settlement negotiations. And the idea is hopefully to resolve a suit more favorably than would in the court. And part of that is, okay, well, it's going to cost us $100,000 to go in court, but if we offer, just for all the defense, maybe we offer $50,000. Now, serving on a school board kills me when you have people and you know that they did wrong and you have a settlement and they're trying to charge you with wrongful termination or whatever the case is, and you're basically kind of giving go-away money because it's cheaper. But that's a calculation that has to be made. But that's kind of, I hate to call it go-away money, but that's really what it is in many cases. And so at a certain point, some decisions are on principle. Say, no, so we're going to defend it. We're going to take this $200,000, whatever, even though it's a $5,000 claim, because we want to make a point. And so some organizations will do that. But that's part of giving clear direction. And that goes to the, risk manager needs to communicate organization's goals and reach the settlement. It's really clear what are we trying to achieve in a settlement agreement. And also, depending on whether the event was insured, will dictate who takes the lead in negotiations. For those that are self-insured, once it hits half the deductible or once 50% of the self-insured retention typically, what then happens is you then have to notify the excess insurer, and then they can decide what point they want to take it over. And usually there's some language that they say, okay, we're going to take over the defense and we'll work with you, or they'll work, they just need to be advised and they'll let your attorney handle it at some point. But that's part of where the insurance requirements might have a say in what goes on. Modifying the consequences of contractual liability. So now we're kind of looking at, again, we talked modifying consequences of tort. Now we're modifying the consequences of cost of contractual liability. So the measures that can be taken, selective part of this is, this really also deals with the contract aspect. Look, favorable jurisdiction for adjudication in the event of a disagreement. Almost all contracts say we're going to do it in our jurisdiction, not in your jurisdiction, or we're going to make it sure it's favorable to us. A lot of times they'll say that's why arbitration is the first thing before we go to court. Include limits of liability. So a lot of contracts, and so this is the thing when I was talking about software. Software or online, if you buy a piece of software and it's for $50 and you keep all your records or QuickBooks and everything gets lost and all your accounts payable, and most likely there's probably something in there when you bought it and it's in the contract language that says we're limited liability to the cost of the purchase of the software. So $50 is all you can get from us if the software fails. And so again, even on storage things, you might have all this information. I can guarantee you almost all of them have a limit of liability, what they're going to be responsible for in certain circumstances. Or it might be limited liability of their insurance policy or those type of things, so they're not harmed. A liquidated damages provision limits the amount for which one party might otherwise be liable, or it can ensure that a minimum level of payment. And so if I was supposed to receive, and this is more the idea of, if I was supposed to receive $5,000 and for whatever reason, and I'll use, this is from an event planning, this is where I typically see quite a bit, that I have to guarantee at least $5,000 in food and beverage sales, and we only get $4,000. Well, liquidated damages basically says, something you're going to pay me the difference either way. So I'm going to be made whole because that was the expectation. You didn't meet your obligation to get enough attendees. So because I could have sold that space to someone else, those are the damages which I suffered. So therefore, this is what you're going to pay. Valuation clause used mainly in transportation or bailment of property in the event of loss, stolen, or damage. So if you consider, again, bailment of property, value of the car stolen while in the shop. What's the car worth? So there'll be valuation. So in that blue book, I'm going to pay you what the blue book price is, and that's how. Or insurance companies typically for cars. Okay, total. What's the valuation? What you're going to get paid back, and that'll be part of it. Evaluate duty to mitigate. Essentially, this means that if a breach of contract is identified, other party will be given time to cure or use good faith efforts to reduce severity of losses. So typically, once we say, oh, this is a breach of the contract, you just don't say contract's done. I mean, in some cases it might, but a lot of times there'll be provisions to say we'll have 2 weeks to cure the situation once we're notified that there's a problem with the software, there was a problem with whatever, the construction or things like that. That we'll be given an opportunity. Matter of fact, in most courts, what they'll say is, look, you did a certain, work on my house or did something, and maintenance, and you did it wrong, and I don't want to, use the person again. Well, if you didn't give the person an opportunity to fix it, and you had someone else, you paid them twice as much to do it, the court may not say, well, you didn't give the person a chance. So that might be part of it. And again, it depends on the judge, jurisdiction, and situation of whether they would do that. On statutory liability, no, there's not a whole lot. Usually the only defenses to reduce fines or penalties are specific to the organization issuing the fine. So depending what the processes are. So within Cal OSHA, there's usually an informal conference process followed by a process to appeal to a board. So, I mean, other than that, the fine's a fine. EPA, if you get a fine, what's the process? You're not going to be able to take them to court typically to say, look, what you saw wasn't really what you saw, but that's the idea of these processes to have some type of dialogue, but that may not be the case all the time. Most other defenses rely on claiming statute was unconstitutional or too vague to be enforceable, and that only works if it's never been tested before. And so, so what, with the Affordable Care Act, people may say, well, that's where the challenges are coming, and so once those challenges are done, you can't really kind of try to claim the same thing, say it's unconstitutional. It's already been determined that it is. Those provisions are constitutional. So now we go into legal systems on here, and we're not going to spend too much time on this. I'm not sure really how much questions will be on there, more than just, even though they put that in the objectives. But the two categories you mainly need to know, there's civil law systems and common law systems, and you'll just want to know the difference between the two. So under a civil law system, it uses comprehensive codes and statutes to form a backbone of the legal system, and in this case relies heavily on legal scholars to interpret the law. And more countries use, which I didn't realize, but more countries use its subsystems than any other legal system. I would figure common law would have been more common, but the civil law system is the one used most. In this case, the judge is a civil servant whose function is to find correct legislative provision from the code of statutes and apply the facts of a case. Their job is not to interpret the law. So it's a little different to say, okay, so they're not looking at intent of what were they trying to do in the law. How does this fit? They'd say, no, here's the facts. They look at, and so what's interesting, having when I've done some, work with some countries in the UK, their laws are pretty specific on what obligations are and things like that. And so that's probably what, that's how the civil law system got developed out of that. Usually they're going to have, in this case, 3 stages. You're going to have a preliminary hearing to submit pleadings, evidence stage, a hearing judge hears the evidence and prepares a written summary of proceedings. And then this goes to the decision stage. So it goes to a completely different judge as a presiding judge. So they, you have a person who bought your, case. They say, here's the summary of it, and the presiding judge decides the case based on the record provided by a hearing judge, counsel briefs, and arguments. There's no jury trial used in civil law system. So whereas with common law, we do have the jury system as part of that. So they go through some of the different elements. And again, I'm not sure. I try to highlight what I think are probably the important facts that you may want to try to pull out of it. But Roman French law, magistrate is the final arbiter of a private law dispute. Court can rely on appointed experts and simply, say, okay, what do the experts say? I'm going to go with that, and what the facts of the case are essentially. German law, German private law is a civil code that took effect in the 1900s. It's really designed as very legalese based upon the content, designed for legal professionals to kind of interpret. Requires a finding of fault on the part of the wrongdoer in a tort suit. So it can't be, so it's very specific. You have to find fault in that case. The German statutes are specific on compensation based upon the type of accident. So if it's an auto accident, you're going to entitle this much. If it's a limb, this is how much. I mean, so they're, severed limb, this type of thing. So they're very prescriptive of exactly what that is. Scandinavian law is, codes based on history, customary law, and codified business practices. And again, there's more details. Like I said, I don't think I'd be surprised if there's too many questions because I just don't see where this, from a big picture, other than to understand there's these different systems out there.
Do they
So,
have an appeals process?
I don't believe so. I mean, because like in the magistrate, for the one that talked about magistrate in the French law, magistrate is the final arbiter of a private law dispute. And in most cases, there really isn't an appeal system. And again, we're talking, on the civil law. So these are more the civil proceedings. These aren't criminal type cases when we talk about these aspects. So in common law system, a judge interprets, and this is, I think there's really the distinction that if there's a question, it's the difference between the two. A judge interprets the facts of a case, examines precedents, so it's not just looking at other laws, and makes a decision based on facts of current case. And so if you look at a lot of decisions, they're looking, okay, what was done before, what are the specific facts, whereas the other system, they're looking, what's the law specific to this, what law applies to the situation, let's apply the law. In this case, looking at the facts, what's been done in the past, makes a decision. And really, fact-intensive relies judges' reasoning for a final decision. So it's kind of, that, and used most in former British colony countries. So Canada, Australia, us, of course, yeah. Other global law systems, you talk about East Asian law, tradition and formal compromise. So East Asian is, they kind of talk about this really in Japan, few attorneys, judges, or lawsuits, and the idea is that compromise contrasted with individual parties asserting their rights in negotiations to settle contract disputes. So it's much more like an arbitration, it sounds like anything else, the way that East Asian laws are. The Hindu law, main probably point out this is that, for those in Hindu countries, there's the caste system that basically, people, once you're in a caste, you really don't move up, you don't move out. This is, where you're going to be. There's 4 different castes that they kind of have of, there's really upper class, lower. I mean, you can kind of get an idea of those. And so their system reflects elements of the old caste system, but has statutory code of that's specific for commercial, criminal, and civil proceedings. So they have a little different there. Islamic law. And I think probably this may be the reason why they put it in there is just because there's so much talk about Sharia law. And I mean, there's the commentators, about the different aspects of what it is, and so they probably want to maybe find a way to put it in here. So a system of law called Sharia law, which is based on the foundation of the Book of Quran. The Quran contains specific precepts about ethics, crime, business transactions, domestic relations, inheritance, and war, but doesn't necessarily talk about the legal consequences. So in some ways, which I've read the Quran, you kind of think, okay, well, our 10 Commandments, talk about, we have that. It looks like the Quran is much more specific on these specific areas. And I think it's a fatwa, I think is what refers to the body of laws developed from the Sharia. And so you kind of hear about the, the different schools. So you have the different leaders of these fatwas, and they kind of talk about the book that they have different specific elements of what laws that how they're interpreting the laws depending on which jurisdiction, and that they're very, it's almost like, there's just very different sects within Islamic law of how they're going to interpret the different situations. The other ones, last couple, are socialist communist law, emphasize state interest over that of individuals. You look at probably Cuba or some others, there really is no private rights, so to speak. Private sector business principles, not necessarily in socialist system. Government owns all property and production, and all contract law is public. So if there's disputes, it's going to go in favor of more of the government or the public interest. And then Russia changed to a civil law country with the fall of the Soviet bloc. Last couple things on here. So we have public international law. Main things to get out of this is, it's really about treaties. When we think about public international law and NAFTA and GATT, it requires, when we have those things, there's got to be an agreement, and those countries then also have to modify their national laws to comply with the agreement. So the treaty signed, which also then requires us to change our laws to comply with it.
We're different where are if there's good disagreements, where are they defined?
It's probably specified in the treaty. No, I think in NAFTA, within there, I think it's World Trade Organization, WTO, it actually specifies. And so I think that, within the provisions of that, and even that goes with the WTO goes to not embargoes. What am I thinking? Free trade issues and things like that. That's where high tariffs, where there's not competitiveness, or people dumping products that would lower the price. I think that's probably where that goes, and that's probably more the public international law because it deals with that. On the private international laws, disputes between individuals or corporations in different countries. Issues within system, whether the main things on the private international laws is whether the court in one country will recognize the decision of another, and they call it a committee, and then whether the court has the right to hear the legal dispute, which really goes to jurisdiction. And so the recent case where we had, where again Samsung and Apple, that was one of the things where they made a decision, and we kind of said, yeah, we're going to ignore the decision regarding, they said Apple infringed on Samsung's. I think in China they made that claim. That's where the court case, but we said we're not going to honor that. I think Obama voided the decision or whatever, however that the correct term was. In that beginning, it wasn't a dispute between countries as much. It's a company organization. Does someone have the right to do and infringe on that? So commercial liability loss exposures. Major categories that we talked about, but the ones we're going to focus on are premises operations, completed products, auto, workers, and workers' comp are going to be the main ones. So when we talk about liability, or premises operations, it's liability arising from bodily injury or property damage caused either by an accident that occurs on an organization's owned, leased, or rented properties or premises. So slip, trip, and fall would probably be, again, it's a premise on that. Or by an accident that arises out of the organization's ongoing operations but occurs away from the premises. So that can also be part of it. Owners and occupiers of land owe a different or higher duty of care to others on premises. Typically, jurisdictions follow reasonable care standards. So the idea is that if you're a grocery store, you invited the public now on there, you have a higher duty of care to prevent people from being injured. A theater, those type of things. So that's what it means by owners and occupiers owe a different standard of care when you invite the public. Organization can be held strict liability for certain operations, and the way we can affect that is hold harmless agreements. We may be able to transfer some of the liability from those operations. Then we go to product liability and completed operation. So rise out of the manufacture, distribution, and sale of unsafe, dangerous, or defective product, or the failure of the manufacturer, distributor, retailer to meet its legal duties to the user or consumer of the product. And basically, the plaintiff must prove that the defendant failed to take reasonable care in the design, manufacture, distribution, or sale of the article. And talks about in order to prove, in this case, strict liability, you have to prove three elements. Product was defective when it left the manufacturer's or supplier's control. Defect was defective condition made the product reasonably dangerous, and defective product was the approximate cause of the injury. Plaintiffs can seek damage from any entity in the process. Now, part of this was car dealership. If I go to a car dealership and I sell a Ford, and who am I suing? Well, there was you can sell, okay, Ford, and then you're going to sell, who in the process are you going to go through? Who provided that? And typically, of course, they're going to go after the deeper pockets, which are the manufacturer of the car. They're really not going to go after the dealership in most cases for that, or at least most likely there's an agreement that says between the dealerships, if you have these issues, we will hold harmless in this case. Completed operations liability, legal responsibility of a contractor, repair, or other entity for bodily injury or property damage arising out of the entity's completed work. Contractors can be held liable after work is accepted if the contractor knew of a danger or deliberately concealed a defect in a completed work. And right of action prevented anyone injured through the contractor's negligence. So the idea being that I built something, and again, from a contractor standpoint, I've accepted the work, but I later find out you kind of knew you used bad materials, you used substandard materials. I can then go after you because I was damaged in the process, and because you knew about it in there. Auto liability, legal responsibility for bodily injury or property damage arising out of the ownership, maintenance, and use of automobiles. most states, and obviously California, we're no-fault auto insurance, which means the car owner is liable for damages arising from any person's operation of auto with owner's express or implied permission. So essentially, if I'd say, oh yeah, you can drive my car, if something happens, my insurance is going to be the one that has coverage in this case for it. The coverage basically goes with the vehicle, is what the idea is. It's not only just the person, even though now I may sue and say, okay, I'm going to try to recover against the person driving and try to recover those dollars, but essentially my insurance is going to be first payer. Anyone who is injured or property damage as a result of negligent use of an auto has a right of action against the operator. So I kind of raise this, not so much in the book, but I think it's important to note. It'll give you some context. But there's essentially joint liability for the employee's negligent in operating an auto during course and scope of employment. So so there's that vicarious relationship that if I hire someone, they're going to go after me, the insurance, me, and then our insurance company is going to pay for the damage caused by that. So that's usually pretty clear when someone's driving a UC vehicle or an organization's vehicle. Most people don't realize, or most employees, I should say, don't realize. Most risk managers know this, but employees who drive their own vehicle for work purposes should understand their insurance is primary. Employers should require an employee to retain higher insurance coverage. So this is actually a technique. So if I allow someone to drive their personal vehicle on business, no matter what, their insurance is primary. A lot of times people, hopefully people have minimum insurance, which is $15,000, which covers nothing. UC's current requirement is $50,000, $5,100 coverage per person and per total. But the higher the liability, you've essentially transferred the risk to a certain extent. You've now said they're going to take the first cut, and then we pay anything after. Because most claims, unfortunately, if you had even a 25/50 or 50, it's going to be eaten up. And then what happens is, with the remaining amount, the employer then will pick up. And so that's one of the things that becomes an issue. So how do you prevent some of that? Is driver selection, training, and monitoring is key prevention technique. Is who you're letting drive your vehicles. Have you done training with them? And are you monitoring the motor vehicle records to make sure that they are a good driver? So liability of operation by others, person who negligently refers a defective auto to another person may be held liable to a third person injured as a proximate result of the defect. This goes to the idea of, if you sell a car as is, this is where the exemption is, I should say, on the premise that the buyer has obligation to the car inspected. So if you say, hey, this is as is, you should get inspected before you make the purchase, because if something is wrong with it and something happens, then at least you're protected in that case. Negligent entrustment is a person who entrusts an auto to an unskilled or incompetent operator may be held directly liable for resulting injuries. So if I say, oh, okay, I know you can drive a car, but then I have you say, okay, go drive the bus. Go drive a 15-passenger, and this is probably more of a 15-passenger van, which we don't have or should not have, and because they handle a little bit differently. And so now I've been, I may have negligently entrusted because I didn't make sure that did a driving test with you. I didn't make sure you could drive it. Or entrustment might even be something as simple as all of our cars, we have all the cars are stick, but there's that one that's automatic, and there's that one that's stick. You've never driven a stick. And, have I now entrusted you to drive this vehicle, and then you get in an accident because you can't drive it, and then so that can be part of liability as well. Auto no-fault laws, global no-fault laws provide stated benefits for all persons injured in an auto accident without need of proof fault. We kind of talked a little bit about some of these different things about no-fault systems, but the main thing is to know is that depending on the state, there are going to be specific requirements of what's required in there, and most of the time, whether you can sue, you still have the ability to sue under no-fault to try to personal injury or those type of things, but essentially, the idea is at least you're going to get your vehicle. Those things, there's not a lot of questions asked, and to try to do that. Workers' compensation. Example of a liability imposed by statute. I think every state has workers' comp laws to a certain extent. Work comp is intended to be exclusive remedy. It means that an employee cannot sue, but it's compensated for injuries and illnesses on a no-fault basis. Now, it can, talks about in the next thing that you can sue for certain circumstances, but for the most part, the idea of the work composition, if you're injured on the job, of course the scope of employment, no questions asked, let's get the medical care, let's get the person, because what was happening before workers' comp in the 1920s, it's like you're injured, okay, well there's another work, I'll just grab that. And so there's actually some videos or some stories, I forgot where I saw, but talked about the whole issues during the 1920s that led to the creation of the workers' comp system and really the abuses of employers that really led to that. So in order, in certain circumstances, to file a tort, injury caused intentionally by the employer. Employee spouse may claim loss of consortium due to an injury caused by employer's negligence. Again, negligence in this case be that not proper guardrails, not proper equipment, things like that. And the last one probably should be reversed. Injury resulting from employer's negligence or torts while acting in some capacity other than employer. So I can assume that the softball team, it's not part of the employment, and something happened, got in a fight. Well, now I can assume even though it's my employer because it wasn't in the course and scope, and that might be a case I can do it because it wasn't in that. Work comp statutes may exempt certain types of employees. In this case, they list farm workers, domestic workers, real estate. The big one, I remember someone I talked to, they said, family member, what do you mean I'm exempt? Well, yeah, your family, you're exempt from workers' comp. They don't have to get coverage. Hold harmless agreements. Employer's liability for injuries. Employees can also be assumed under contract. Employer may agree to indemnify another party against certain claims an employee makes against the contracted party if they're injured. So there might be some agreement, someone didn't read, that says, hey, well, if something happens and, because of negligence where you most likely, maybe the employee could then sue that other employer because it's not their employer, and they can say, I want to recover. They might say, nope, you can't do it, and if you do so, then your company has to hold us harmless, and your company's now going to pay for that. So those are certain provisions that can be in there. So the case study. We'll go through some of the questions here, a little bit over here. Case facts. So you're the risk management professional for a property development company that owns several large shopping malls and 2 hotels. Okay, you are in the process of renegotiating the liability insurance program that is due for renewal in 3 months. As part of the process, you must assess the organization's legal and regulatory risks and determine risk treatment options. Okay, so property development owns several large shopping malls and 2 hotels. So obviously the answer is the bottom, but we just want to kind of go through why these are the answers. So which one of these sources of legal liability includes wrongful acts classified as torts? Okay, so we talked about, the other ones are categories, if you remember. So the categories we had, are statutes, and we know statutes and regulations are kind of the same thing, right? And so it's not a contract, so it's really negligence in this case. Negligence is a wrongful act that you can do a tort. So again, type of question that you have there. So does negligence as the source of legal liability includes the wrongful acts as torts? Describe the premises and operations liability loss exposure for this property development company. So what they include on here is the premises and operations liability loss exposure relates to liability from bodily injury or property damage caused by an accident that occurs on the organization's own leased or rented premises. They just kind of regurgitates. But if you think about the concepts here, premises and operations. So if I have a mall, okay, well, I have a lot of people going on the mall. We have parking lots, so we need to make sure that the trip fall hazards out there. If there's proper lighting at night, so when people are walking out, that we don't have exits locked in the event of a fire. Security might have to be out there, might be held liable for that. The hotel situation, floor, things, rooms properly maintained. Do they have, the locks on the doors? Fire exits. Yeah. So I mean, there's all, you can kind of think of the premises liability. So that's what kind of. I don't think they really gave a great answer, but that's what we're looking at. It says property management company contracts with a security firm to handle all security matters for its malls and hotels. Describe the requirements for contract to be enforceable. Okay, so we talked about to be an agreement, consideration, capacity to contract, and legal purpose. Almost everything there on. Again, this is definitely going to be a question somewhere. It's going to have some type of thing where you really need to know that part. Last couple here, customer trips getting on the escalator at one of the malls owned and operated by the property development company. The customer suffers significant injuries and initiates a civil suit against the company. Describe the types of monetary damages the company may have to pay if found negligent in this case. So the answer they give is a wrongdoer in a civil case will have to pay compensatory damages to the injured customer. Compensatory damages include special damages for expenses such as medical costs or lost wages, and general damages for losses such as pain and suffering. So what are some of the things? It talks about, getting on the escalator at one of the malls. Well, on the prevention aspect,
failure to maintain your equipment.
so it's a failure to maintain. And so part of the, the defense in this case, look, no, we have it checked out once a month. We do regular tests. Does it have markings right before you get on and off? I mean, those are the type of defenses that can be used to say, no, we're not going to pay these claims because this was not our fault. In this case, the person, because should know how to get on escalator and get off of escalator, and it wasn't because of failure of the equipment per se. Or if there was a failure of the equipment and you have a contract, whatever claim you pay, then you subrogate against the maintenance company, saying, look, you did not maintain this up to the requirements that we expect. And so just because you get sued doesn't mean you just don't go after someone else in the process. And so subrogation is that process. Okay, explain how the property development company could use hold harmless agreement through or limit liability from its tenant. The property development company could use hold harmless agreements and leases with stores and other tenants. Such agreements will require these tenants to hold the property management company harmless from claims made by third parties who are injured by the tenant's negligence. Example, they give a customer a restaurant within the mall were to be injured as a result of falling on a spill that had not been cleaned up by the restaurant staff. The property management company's liability could be limited related to the customer's injuries based upon the hold harmless. The idea is even though they're the property owner, hey, at least you're responsible for that. Anything that happens in there. And if they, so the idea is they're going to sue the bigger pockets, and then, they're saying, no, if that happens, you guys are going to take care of it for us. Describe some of the risk control areas that would be of particular concern to the risk management professional for the two hotel operations. We've kind of talked about this a little bit. Hotels, consider housekeeping, maintenance, in the parking, maintenance, in the parking lots, building exits, entrances, walking surfaces, stairway, elevators. Hotels, okay, from a work comp perspective, okay. One of the, there's actually a bill to require for hotels that they be allowed to have fitted sheets. And so here's the reason why, is that when you do make hospital corners and you have to tuck and do all these different things all over, if you can imagine how many beds that they have to do, they actually have a lot of, they're seeing a lot of claims from housekeepers. Fitted sheets are typically used, and there's actually tools to help, do that, but fitted sheets aren't used because they don't look as pretty, they get wrinkled, you can't fold them nicely. So this is an issue that we've actually looked in our dorms, that and then also the idea is that fitted sheets break down quicker. The elastic breaks down when you wash them more, so you may have to replace them more often than the regular sheets. But from a work comp perspective, it's really being looked at as, hey, should fitted sheets be used because it'll actually reduce workers' compensation claims, and who cares if there's wrinkles when they pull up back to bed, as long as, so anyway. Last couple, which of the following is a measure that can be taken to reduce the loss associated with contractual liability? And so in this case, again, contractual, again, think of, okay, can we do comparative negligence on contractual? No, negligence is negligence, that's tort, right? Legal privilege, no, that's, that goes in a different category. Risk avoidance, there's, what is that really? I mean, can we avoid it if you can't do it? Well, that's not in a contract. Well, that means we're not doing it, so that's not the answer. So nothing else. By process of elimination, D would be the answer. A liquidated damages provision limits the amount for which the management company might otherwise be held liable. And describe the measure the risk management professional should take to assist the organization in modifying the likelihood of statutory liability. In this case, risk management professional must understand the statutory compliance requirements that apply to a shopping mall and hotel operations. In this case, might be ADA, would be probably one of those. Internal experts or internal consultants can assist with this process. So they kind of talk about, they don't say, okay, what are the things? I think it's helpful if they actually said, okay, here's the bigger picture of what these liabilities might be. They kind of say what the process is, which is important. You want to know the process. But I think when you give examples, you'll probably have a better idea of, oh, this is the process of what are the exposures that we might have. All right. Went through it, went over, sorry. Next week we will be doing chapters 7 and 8. We've got 2 chapters to do next week. Actually, I think those will probably go pretty good there, and we're making it through. So again, thank you everyone, and we'll see everyone next